Hi, this is a recap of constitutional law for students who are studying administrative law. Obviously, these are both areas of public law, and administrative law really builds on some of the knowledge that comes out of constitutional law. So the intention of this video is just to quickly talk through some of the issues that were raised in constitutional law, to refamiliarise yourself with them. And if you're currently studying constitutional and admin at the same time, maybe this is a chance to actually read a bit ahead, or at least read some summaries of some of these concepts so that when you hit them in admin law, you'll understand what they mean. So the first concept I'd like to bring up is the idea of federalism, and that's really about the construction of the Australian system of government. So the Commonwealth government, the state governments, and of course the local authorities and local councils, which we talk about as being another level of government, but really they're more statutory authorities that are created by the state government. That's important because the local councils, like other forms of authorities, don't actually make law in the same way that the state or federal governments do. They create regulations, they create bylaws, they're basically creatures of administrative law. Local council is an administrative body, it is not a legislative body. And the things that they do have to be consistent with their enabling legislation in the same way, I guess, that the other governments have to operate in a way that's consistent with their constitution. So a basic understanding is important, at least, of the different levels of government, the interrelationship between them, and some of the prohibitions imposed by their different constitutions on the way in which that they act, and the kinds of powers that they have. Next, we have the concept of parliamentary supremacy, and this means that the lawmaking ability of Parliament is supreme over all, except, of course, the Constitution, which binds it. This does mean that there's an important role for the courts in statutory interpretation, in governing and regulating what the government does, or what the legislature does, and keeping those powers in check and making sure that legislation is consistent with the Constitution. And when we look at administrative law, in making sure that rulings, guidelines and decisions made by administrative bodies are consistent with the legislation that creates that body and enables those powers. And that is the fundamental foundation of our system of judicial review. It's on the legality of those decisions. Next point, doctrine of separation of powers, is something which is something that you will have studied in a lot of depth in constitutional law. It's very, very important here. It's fundamental, really, to understanding what administrative law is and how it works. So remember, there's the legislature, the executive, and the judiciary. And another term for the executive is, of course, administration. So remember, those terms overlap. And generally, those bodies are kept distinct, and their forms of power are distinct. Now, in the Westminster system, we have a little bit of overlap between the executive and the administrative, because ministers of government are members of both forms of power. So sometimes you can be a little confusing and a little hard to sort out. When a minister does something, are they doing that as an elected official and a member of Parliament, or are they doing that as the head of the executive, or the head of an administrative body, head of a bureaucracy? And that is one of the things that the Westminster system does allow, a little sort of blurring of those lines, which, for instance, the American system doesn't. The other thing is the absolute distinction between judicial power and other forms of power. And you remember the Boilermakers case talked about this, and that was a case where there was an attempt to confer judicial-style powers onto an executive body, and that's something which our system will not tolerate. And it does mean occasionally you have to have separate bodies to administer something and separate bodies to make judicial rulings. This is important in admin law for several reasons. Part of it is the way in which we set up our bodies and the way in which we separate those powers. It also means, it also underlies the division between merits review and judicial review, and why we have two different systems, because merits review is really just a form of bureaucratic review. It's appealing up through higher levels of a bureaucratic system. Even though the AAT may sort of look like a court, it's really basically just taking an appeal up to a superior level. Whereas judicial review is judicial oversight from outside, and it's coming in and actually looking at the legality of a decision. They kind of look similar, and the results might be similar at the end of the day, but they're different forms of power. The other thing that separation of powers is very important for is commissions of inquiry. We'll be looking at those. Commissions of inquiry are executive/administrative bodies, although often they take the form of something that looks like courts, and they often have judges as members overseeing the process. And there's a misnomer that the media uses quite often. They talk about judicial inquiries. A judicial inquiry means absolutely nothing. They're a royal commission or they're a commission of inquiry, and we just kind of confuse matters by putting judges in there quite often, and it's a technical legal issue, and we don't really necessarily expect the media to understand it, but it's really quite important, and we'll look at that again when we look at commissions in detail, and why, for instance, the Fitzgerald inquiry couldn't actually prosecute people that they found guilty of corruption. There's very important legal reasons for that. We'll look forward to talking about that later. The last thing I think that we need to remember is the idea of rights, and that rights can come from different places. So there are fundamental rights that are written into the Constitution, but there are not very many of them. Many of our rights actually are enacted in legislation, or maybe we have an argument that they're codified, that they're rights that exist and that the legislation simply recognises their existence, which is a subtle difference, but it means that these rights have an existence outside of the legislation that gives life to them. England, for instance, has an unwritten constitution, and they're quite happy with this idea that rights are sort of out there and we don't write them down, but we sort of recognise them through common law. We are sort of halfway between them and the United States system. The United States system, of course, they have a Bill of Rights, which has the advantage of enumerating rights, making them more certain. But at the end of the day, it can create problems. So if you create a right that's anachronistic, it's very difficult to remove. And the debates that are going on around weapons and firearms are a great example of that, where the original right to bear arms came out of a different time and is expressed in a different way, and maybe isn't so relevant today. But that's a different topic for a different time. The other thing to talk about in terms of rights is the implied rights argument, and you'll recall there's a sort of interesting legal status to this argument about implied rights. It's mainly an obiter dicta argument, but this comes out of the political broadcasting case, and a discussion as to whether there are some rights that are implicit in the idea of a democracy. And you'll recall in that case there was an attempt to ban communication leading up to an election. And one of the discussions that occurred, and again it was obiter dicta at the end of the day, was that the very concept of a democracy involves the right to communicate. You just can't, and you can't have a democracy without the ability to communicate information. Therefore, the fact that the Constitution talks about a democracy means that some of these rights are so implicit that they don't have to be written down. Of course, as soon as courts say things like that, other people go crazy about judicial legislation. It's just judges making things up and so on. So there's a whole debate around that. And it's something that we will touch on again, because really a lot of what's happening in the field of administrative law has been about the development of fundamental rights, the expression of those rights in legislation, and then the gradual erosion of those rights by successive governments who are not happy about being having oversight and having control on what they do. And then the argument is, if we remove those rights, are we just removing a right that's a creation of a piece of legislation? Or we were removing a right that's a fundamental right that existed beforehand that the legislation simply recognised and codified? Again, subtle distinction, but very interesting and very important. Anyway, that's a crash course through constitutional law, at least the pieces of it that I think are important for administrative law study. And as always, these are the sort of things that we can talk about more in the forums or in workshops if you're unclear about any of those concepts.